Code of Professional Responsibility Canon 12.07 and 12.08. Canon 12.07 A lawyer shall not abuse, browbeat or harass a witness nor needlessly inconvenience him. Rights and obligations of a witness. A witness must answer questions, although his answer may tend to establish a claim against him. However, it is the right of a witness, 1. To be protected from irrelevant, improper, or insulting questions and from harsh or insulting demeanor, 2. Not to be detained longer than the interest of justice requires, 3. Not to be examined except only as to matters pertinent to the issue, 4. Not to give any answer which will tend to subject him to a penalty for an offense unless otherwise provided by law, or 5. Nor to give answer which will tend to degrade his reputation, unless it be to the very fact at issue or to a fact from which the fact in issue would be presumed. But a witness must answer to the fact of his previous final conviction for an offense. Rule 132, Sec. 3, RRC, Canon 12.08. The lawyer shall avoid testifying in behalf of his client, except a. on formal matters, such as the mailing, authentication or custody of an instrument, and the like, or b. on substantial matters, in cases where his testimony is essential to the ends of justice, in which event he must, during his testimony, entrust the trial of the case to another counsel. A lawyer shall avoid testifying in behalf of his client v. although the law does not forbid lawyers from being witnesses and at the same time counsels for a cause. The preference is for them to refrain from testifying as witnesses, unless they absolutely have to, and should they do so, to withdraw from active management of the case. V. The duty of a lawyer to assert every remedy and defense that is authorized by law for the benefit of the client, especially in a criminal action in which the accused's life and liberty are at stake, is also being considered. Case: John R. Santiago v. Attorney Edison v. Ruffin AC number 6252. October 5, 2004. Note: facts and issue relating to Canon 12.07 and Canon 12.08 will only be presented facts. Q. This is a disbarment case filed by B. the JMP employee John R. Santiago against Attorney Edison Ruffin. Q. Santiago alleged that Attorney Ruffin executed an affidavit in favor of his client and offered evidence. Attorney Ruffin stood as counsel and as witness of his client, and Attorney Ruffin, as alleged by Santiago, waited for him together with his men and disarmed Santiago and uttered insulting words at him. Attorney Ruffin contentions, Q. as to his alleged violation of Rule 12.08 of CPR, lawyers could testify on behalf of their clients on substantial matters, in cases where their testimony is essential to the ends of justice. Santiago charged Ruffin's clients with attempted murder. Ruffin said that since his clients were in his house during the alleged crime, that's why he said his testimony is very essential. Issue: whether or not Ruffin is guilty in violating the Canon 12.07 and Canon 12.08 held. Q. A lawyer is not disqualified from being a witness, except only in certain cases pertaining to privileged communication arising from an attorney-client relationship. Reason: the difficulty posed upon lawyers by the task of dissociating their relationship to their clients as witnesses from that as an advocate. Note: a witness must only say what happened. Only the truth. As compared with the task of a lawyer who will use all the available remedies and actions in his arsenal for his client to win the case, Q. it is difficult to distinguish the fairness and impartiality of a disinterested witness from the zeal of an advocate. Q. the preference is for lawyers to refrain from testifying as witnesses, unless they absolutely have to, and should they do so, to withdraw from active management of the case. Acting or appearing to act in the double capacity of lawyer and witness for the client will provoke unkind criticism and lead many people to suspect the truthfulness of the lawyer because they cannot believe the lawyer as disinterested. The people will have a plausible reason for thinking, and if their sympathies are against the lawyer's client, they will have an opportunity, not likely to be neglected, for charging that as a witness he fortified it with his own testimony. The testimony of the lawyer becomes doubted and is looked upon as partial and untruthful. Supreme Court decision Q. in the case at bar, Attorney Ruffin cannot be administratively liable because it's a duty of the lawyer to assert every remedy and defense that is authorized by law for the benefit of the client. Remember, there is a criminal case of attempted murder against his client which will deprive his client of his life and liberty, if they fail to display a good defense.